All right.
All right. Let me see if I can share screen and then attempt to play the PowerPoint and give my usual caveat. Window. Yeah, all right. Let's see. Are you guys seeing that screen?
Yes, it's starting to come up.
Okay, let me do a slideshow from the beginning. Okay, and I can't see you, which always freaks me out a little bit, but I'll just talk to this computer right here. Okay, so my name's Colin McCarthy. This is our continuing new manager education series. We're going to be educating folks today about contracts. The lawyer warning caveat at the beginning of this is that these are generalized statements about laws and principles, and they should not be relied on for legal advice, specific legal advice. If you have a question, almost all lawyer questions or legal questions are fact specific. So you'd be well advised to contact legal counsel to get the specific legal advice and not rely on the generalized statements that I'm going to be making today in this presentation, which is, of course, yours to share internally. And we'd very much appreciate it if it stays internal. So, Angus and Terry is a law firm that has been specializing in community association law for over 35 years. We've represented thousands of community associations in California, Florida, and now Ohio. We've got extensive experience in the general counsel arena, which is what we're talking about today, as well as the construction defect area as well. So if you have associations that are less than 10 years old and are having issues with the buildings, we can certainly help assist you in getting the repairs that would be needed and to minimize your financial exposure in that regard and help you get some money to pay for it. So we can do all of that and do a lot of the general counsel stuff. So actually all of the general counsel stuff. So our deal going on right now that Ivy would want me to tell you about is new clients, i.e. new associations that sign up with us get the special rate of $350 an hour. That's for 6 months. And it doesn't matter if it's Julie working on it or me or whomever, the rate is the same. It's $350 for that first 6 months. And for those of you who don't know, Julie is the managing partner at the firm and has the highest rate. Included in this deal is a free board training, and a lot of times that can be helpful. I recommend it just for that. You don't have to spend any money whatsoever. You just sign that rep agreement with us, no deposit down, and I can come over and train your board members to be better board members and not to annoy you so much. And the outcome of that board training usually is a smoother flowing functioning of your board with them out of management's hair, letting management do their job and letting them keep their fiduciary obligations up. So if you have an association that's in a bit of a pickle where board members aren't getting along, those can be really helpful. And so we would recommend that you reach out to us, get one of these agreements signed, get your free training, and then, if nothing happens, you don't need to use us for anything. So it's a pretty good deal as far as deals are going. All right, I just gave the disclaimer. I'll do it again. You guys can see it. It's not legal advice, just general information summary for what contract work today. Current clients just contact us for specifics. Prospective clients can also contact us if you need general counsel assistance. Many people don't know that the communications made in the formation of an attorney-client relationship, i.e. before the relationship has formed, but with the intention of possibly forming one, those communications are also privileged. So any communications you would have with us in a contractual phase for which the purpose is retention, you can speak to us candidly, and that is not, that's privileged. It's kept between the lawyer and the client. The reason we do all of this too is that, the laws do sometimes change. They change quite frequently, as a matter of fact. If this gets relied on 3 years from now and something I've said here is contrary to the law later, I don't want to be, blamed for it. Nor do any of my partners at Angus and Terry. So you're welcome to keep it internally. We hope you enjoy it. And let's get ready to have some fun. Let's talk about contracts and the basic and intermediate principles thereof. Before we do that, I could tell a joke, but I would be telling it to a laptop and not sure. Would anyone like to hear it?
Of course.
All right.
Go for it.
Always.
This was told to me recently by a vendor who shall remain nameless unless the joke is bad, in which case I will reveal his name. Did you hear about the dentist that got an award?
No.
Yeah, it was a little plaque.
Oh my God.
That was good.
I like that one. That was nice.
All right.
That was good. I like it.
All right. So that was, I think that was Rob of Construction Management Services who gave that to me. So there. All right. So when you're leaving today and thinking about that great joke and all of the stuff that you learned, what we want you to go away with today in regards to your contracts with your vendors and your big projects, plan ahead. We want you to understand the difference between oral and written contracts and why it's important. We want you to understand the kind of important contractual provisions in every contract, and then what to do when things go wrong during the performance of the contract, and then why and when and how to terminate. Those are kind of the thrust of what we're going to talk about today. All right. So plan ahead. I mean, this is just like anything, right? So you want to make sure that before the time to do the work, you've got competitive bids from qualified vendors. Of those vendors, you want to check references, make sure they're good. You will have a cadre of experience with your associates there, so rely on your associates for who's qualified, who's good. Check their license status, even if they've been doing business for a long time. Sometimes licenses get suspended, and that can be a real problem legally if you've retained and have performed work an unlicensed contractor or things of that nature. So always check their license status. That's pretty easy. You just go to the Contractor State License Board website and type their name in. Insurance status. Similar thing, but this you have to check with them directly. Make sure that they are insured and that they have the appropriate insurance. And there will be contractual provisions within most agreements that have that. And the reason is that you want, if they do some work and screw up, and that screw up hurts somebody or hurts your property or something like that, you're going to want to have the insurance be able to backstop them, because a lot of vendors and contractors are not made of gold and are hard to get recoveries from. And so their insurance is important, and also important if somebody else sues you, the association, for something that the vendor did. And we'll talk about that in a little bit.
Hey, Colin, I'm going to chime in here just real quick. For Colin's employees, this is why ERC is so important, to make sure your vendors that you're using are certified through ERC, that they take care of the license check and insurance check, make sure things are current for us. So make
Okay.
sure you're using ERC. Do not omit that step. Thank you, Colin.
Sure. Hey, can you just, for my benefit, what is ERC?
Enterprise.
Risk control.
Risk management.
ERC, enterprise risk control.
There you go. Risk control.
And is that a program or a vendor or an internal kind of process?
A vendor
Oh, okay.
did it for us.
All right. I hope somebody reviewed that contract. I'm just kidding. All right. Okay. So good resource there for you. It sounds like you've got all of that kind of internally handled. So going through that process will help with those middle 3 bullet points that you're talking about. The last thing that we always encourage is that if for big contracts, especially with a large project or a large financial figure on the line, is that you get legal to review it. We know that your boards are a lot of times reluctant to do that, but it's very much a case of being penny wise and pound foolish to not have that review, because your boards will want to save a few bucks on the front end and not have it reviewed. And then if you miss a key term and get sued and you don't have the right indemnity provisions in that agreement, then you wind up paying a ton more because you're going to pay the lawyer to defend you in the lawsuit because you didn't have the right indemnity agreement in the contract, which would have, saved you a ton of money in the long run. So there are multiple other scenarios where your board would be wise to consider legal review for the written contracts, so that they save money in the long run. All right, so that's the plan ahead part. Oral versus written contracts, just like it sounds. There are handshake deals, and then there are those that are reduced to writings. They both are agreements. There are a host of different laws that favor written contracts. The statute of frauds has a certain parameter. I can't remember what it is, but if it's at least $1,000 or over a year in term, the agreement is required to be in writing, generally speaking. And writings are better because they provide the clarity that you need. Having an oral contract it can be enforceable, but it's hard. You have to spend money on an attorney to help you enforce it versus a written contract where it's all in writing and the legal review is a lot cheaper than having to pay a litigator to enforce an oral contract. So the lawyer is always favoring a written contract, and for the reasons I just stated. And then you should be asking lawyers about key contracts or key provisions, but that'll come more in the review. This last bullet point is important because a lot of times you will just get a proposal or a contract that's their standard contract, and you don't ever really want to sign those, at the very least without written review, because they're always going to be favorable to that vendor. Right. So some of those contracts will not be negotiable, like ones in fire alarm systems. Those are all pretty regimented by industry, and they all have specific fire regulations kind of informing them in the background. And then they all are out of New York, and none of them want to negotiate, and they say take it or leave it type thing. But you should always, always, always have a lawyer review the contract, even if they're not going to change their terms, because if they're not, you will be giving your board information on which to make a decision, right? Because if they're not going to change terms that are in their boilerplate contract, the lawyer can at least tell you what the risk is, and then you've entered into the agreement with your eyes wide open, or you've declined it because you've decided it's too risky and you're going to find another vendor. The boilerplates and proposals, avoid them at all costs, all right? Or at least have somebody review them, and it will save your association in the long run. Important contractual provisions. Now, these are the 5 or 6 that we kind of look at. Some of them overlap. Scope of work, and that's really important because that sets forth what exactly the vendor is going to do. And you and the vendor got to be on the same page on that. That will always be reduced to a writing. And so you will want to be able to be clear that the writing reflects what you, the association, wants to have happen. And we'll talk a little bit more about it later, but that one really is not so much for the lawyer to review, but for the management company to review with the vendor, management / association to review with the vendor to make sure that what you're asking to be done is actually going to be done by that contract. And so that really is a critical piece of the contract. And we certainly can help in that, but we're not the ones out there at the project, so we don't know necessarily how many coats of paint need to be on it or on a particular building exterior or what the waterproofing should be or what you've contemplated, because by the time we get it, that scope has already been worked out and we're just reviewing these next terms that we're going to talk about. And so we will remind you to be extra sure and go over that scope of work before the contract is signed, because if it ain't in that scope, it's not getting done. Okay, insurance terms are key. How much insurance the vendor is required to have, and whether the association is required to have insurance. In some building contracts, they will ask that you have builder's risk insurance in case anything happens to the building while the project's being done, so that you can be protected. Some contractors insist on that. Whereas you will, and the law will require those general contractors to have certain forms of insurance, like workers' compensation insurance for their employees and things like that. I did, since we're on insurance, I did hear another insurance joke. And I'll tell it right now, and I think it's okay to tell. Did you hear about Adam and Eve? When they met an insurance broker in heaven.
No.
The insurance broker said, "Oh, I can see that you don't have any coverage."
All right. All right.
I don't like that one. Not very good, but it's an insurance jokes are few and far between. So the only other one I know is the Fleetwood Mac one. So if any of you hear of any insurance jokes, I would like a special request for you to please email me it or call me so that you can share it with me. I need to expand my range. Indemnification. That's a lawyer word. And what it means is, will the vendor pay you back if there's a lawsuit that relates to their work? Or otherwise, so if they do some work and it hurts somebody or damages some property, and you get sued, the association, will the vendor be required under the contract to pay for your legal fees, your settlements, and or both of those things? And so those are important provisions. And you'll need to be careful in evaluating your contract to make sure that they have the right ones in there. And we'll talk about that in a little bit. Limitations on liability. What that means is if the vendor breaches the contract and you have to sue the vendor, is there a provision in there that says, yeah, you can sue us, but you can only get X amount of money by a contractual agreement? So the law in California and many other places in the United States allows people to freely engage in contractual restrictions on the amount that you can recover from the other party if you both agree to it. So a lot of examples of that are sometimes, the limitation of our liability is whatever we have in insurance coverage for the particular issue, right? So that people don't want to have to pay out of pocket. Another limitation that they sometimes will do is they say, you can sue us, but the amount of damages you can recover in total is the amount of this contract and no more, the total contract price and no more. So that way they limit their risk to the amount that they would be getting in the contract in the first place. Those are negotiable terms, and you can go back and forth on them. So if they are in the agreement, you want to be aware of them. You want to be aware of what you can recover, because sometimes a contractor screw up will cause you damages elsewhere, not just on the agreement, but what are called consequential damages. So if a vendor doesn't get their SB 326 work done on time like they said they would, you might get fined by the state of California and have to pay attorney's fees to somebody because they sued you because you didn't get it done in time. And then that would be a consequential damage of the breach of contract for the vendor's failure to do the work on time. And if there's a limitation of liability provision in there, you might not be able to get that recovery. So those are kind of the things that this is just kind of issue spotting. You're not expected to know all this, but I'm giving you this so that you understand kind of the basics here. And a warranty is the same thing. How long does the vendor warrant their work for? And if they're installing a product, the product will have a separate warranty in addition to the labor, which is how long do they guarantee it for? Depends on what they're doing. It can be anywhere from 30 days to 10 years, depending on the project. And the negotiation, again, some of that is negotiable. Termination provisions is what it sounds like, is how does the contract end? Does it just end when the work is done? Is there an outer time limit? And what are the provisions if somebody is naughty and doesn't obey the contract and is in breach? Okay, so we'll go over each one of these now. The scope of work, this is what we were talking about earlier. Okay, so don't assume that everybody's agreed to what the scope of work is. You have to make sure that the writing reflects that. So a lot of times the scope that was proposed will be attached to the contract, but you got to make sure of that. The lawyer will tell you that the scope of work is attached as Exhibit E or is the bid proposal on X date. So make sure that bid proposal of that date is the one that you've contemplated to be done, and walk through the proposal with the contractor to make sure that you guys are both on the same page. And it's okay to be specific, and you should be specific. If you have specific expectations and about what needs to be done, make sure it's included in the scope of work. And if it's not, they'll say, you know what, we did agree to paint this thing, but we didn't talk about priming it. And you might have assumed that priming was part of painting, but not. Or what do you do when there's damaged wood that they're painting? Is that included or not? If they come across wood that needs to be replaced, who pays for it? How much is it? All of that. So that stuff is in the scope, and will also be in the contract as to how to deal with those contingencies. And this bottom point is correct, is that you can avoid most probably disputes over clear language if you have clear language in regards to that scope of work. So, all right, insurance. Obviously, workers' compensation is necessary in case a worker gets sued. It's required by law for general contractors to have it. So that because their exclusive remedy is to have a workers' compensation action, they can't sue their employer. And so the state requires the employers to carry workers' compensation insurance. And so those should be included in the contract. And most of them do, but they might not be. So you'll want to make sure that's in there, or your attorney will. The other insurance that is typical and that covers a lot of contingencies is this commercial general liability insurance. And that is exactly what it sounds. It's liability insurance in the commercial setting for business type entities such as a general contractor that defends them and helps them pay for lawsuits that result from their work. So if they, build a deck and somebody falls off the deck because they didn't nail it in right, that person who fell off is definitely going to sue them. And the commercial general liability insurance covers them. If they build a building and they didn't build it right and water gets inside and it damages the structural framing of the building such that the building may collapse with continued water intrusion, the association of the condominium complex or townhome complex is going to want to sue that developer if it's under 10 years. And in many instances, in most instances, they will have commercial general liability insurance to protect them. But you'll want to make sure that those provisions are in the agreement and what are the requirements of those insurance provisions. What kind of insurance do they have, and who gets insured? In many instances, we, as your attorneys, will ask that the association also be named as an insured. And the reason for that is that it cuts out a lot of the indemnity issues, because if you're sued and you are an insured, i.e. you have been named as an insured by that, by your vendor, then you have the contractual rights against that insurance company and that they are supposed to defend you in the lawsuit. And you don't, and that they will if you are endorsed as an insured, not certified. So that last checkpoint there talks about a difference. So a lot of times you will get a certificate, which has the value of the paper on which it is written, versus an endorsement, which actually names you as the insured, because the certificate just is something that says that it has no legal effect. If you see your name down there and it says, oh, the association is an additional insured, but unless the policy itself endorses you as an additional named insured and you become part of the contract, the certificate means nothing. That's why the endorsement is important. And I think our next slide kind of shows it. See, so this is a certificate. You will see these all the time. And you see the very first thing up here. I don't know if I can highlight it. No, I can't. Oh, I'm going the wrong way, sorry. But the very first sentence up there, for those of you with keen eyes, you can see that it says this certificate is a matter of information only and confers no rights upon the certificate holder. Right? Then what the hell is it? That's nothing, is what it is. So avoid these, avoid certificates. What you want is a contractual provision that endorses you. And that's what this is. This is an endorsement. See how it says it must be endorsed. And without the endorsement, you don't have those rights. So, sorry, this is the endorsement. And you see insurance, which is something I did for a while. And I'm surprised I don't have more jokes because I've done it for a while. But every insurance policy will have this kind of bolded contractually. Dang it, I tried to highlight it again. Sorry. These are statutorily kind of required fonts and size requirements. Like it says up top, this endorsement changes the policy. Please read it carefully. So then you know you're getting somewhere if you have something that changes the policy. And then indeed, it says the additional insured is the city of San Diego, or in your case, San Diego Yerba Buena Homeowners Association, who would become the additional insured in that situation. And this is the vendor's insurance. Sometimes they will, if there's a cost, they will try and pass the cost along to you in the contract. Sometimes there's no cost. Sometimes they will pay for it if there is a cost. Just depends on the deal and how bad they want it and all of that. But it should be part of it because it protects the association for those lawsuits that I was talking about earlier. All right. Indemnity provisions. These are what I was talking about earlier. That's the fancy legal word, indemnification. And the more plain English is that hold harmless provision. And hold harmless is kind of the best. There's a scale of these things. There is, we'll indemnify you if you get a judgment against you 10 years down the road that meets these specific qualifications. Or there is, we will hold you harmless from any and all damages as a result of the work. And that is a very broad provision that says, hold you harmless means we'll pay for everything. So that's kind of the scale of things. And what these provisions do is, as indicated there in the first bullet point, they allocate the risk and expense when there's a breach or default by a party or when there's another lawsuit. They should always favor the association. There are sometimes a few exceptions, like I said, the fire alarm ones. They will tell you to pound sand if you try and get indemnity provisions in the contract, which I have tried. But you will always get them at least as much as they are required of the association. Sometimes provisions will require the association to indemnify the vendor in the event that something about the project, such as pre-existing construction defects or pre-existing asbestos or something, gets the vendor sued, and then they will have a provision. But you at the very least should have one that matches theirs, and that offers the same reciprocity. When we're looking at these clauses, we look to see damages versus liabilities. Damages is a specific legal term, meaning what is the compensation for the wrong, whereas liabilities is a broader term that means what are you liable for as a result of this happening. So the damages is kind of more limited, and you might only recover for what you have to pay in damages versus liabilities, which may include your legal fees and things like that. These provisions will sometimes include a duty to defend, meaning that the vendor will have to pay for your defense. And usually that's connected with an insurance contract. But if that language is in there, an insurance company will rely on that language to pay for your insurance, sometimes without the additional insured endorsement, if the indemnity language is strong enough. I mean, I can't tell if you guys are all asleep right now. I know I'm almost about to go to sleep talking about this stuff. Jeez. Indemnity is no fun. Let me tell you that. That's why you want your lawyer to look at it. That last bullet point there is no indemnity for sole negligence or willful misconduct. The latter of which is very, these are both kind of operation of law type things. But if you think about it, willful misconduct is where you intentionally harm somebody. So the law doesn't want, and indeed precludes as a matter of law, you getting insured so you can go around and punch people in the face, right? So you don't want to, there's no insurance for that, because we don't want to encourage a society of intentional harmful people. So, okay, well, let me think. I don't know if I have a joke that goes with this. Has everybody heard my cow joke?
I haven't.
Okay. All right. I'll take that as an invitation to tell it. If you have heard it, you know what? If you have heard it, I want you to see if you can give the answer. All right. Give the punchline. What do you call a cow on the floor?
Ground beef.
There we go. Boom.
Oh, what was the punchline, Brad? I was clearing my throat as he said it.
Ground beef.
I like that one.
Okay, I love it. I love that one.
All right. Good job, Brad.
There's a less appropriate version that we won't talk about.
Oh, I haven't heard that one. So
Yeah, that's
maybe-
why.
maybe went over beer.
maybe when we're not recorded.
Yeah, I've got a ton of lawyer jokes that are completely inappropriate that I will not share.
I'll be talking to you afterwards, Brad.
Yeah.
I want to hear your other version.
All right. Limitation on liability provisions. These are basically what I talked about earlier. They cap the exposure for the vendor. And they can be both ways. But usually you're the one paying and the vendor is the one providing a service. And the person providing the service will want to limit the amount of money they have to pay if they do it wrong. And so, as I said, they do it in several different ways. They tie it to insurance. They tie it to the contract amount. They say no damages whatsoever can be recovered except for, what's expressly a part of this agreement and things of that nature. You're basically going to want to understand before you sign a contract, what can the association get in a lawsuit against this vendor? And these limitation on liability provisions tell you that. Warranties are just what you think they are. They guarantee the service or the work or the product for a certain duration. And they have limitations on them. A lot of contracts don't have any warranty language at all. You can ask that they be added. And what they do is basically guarantee, like if somebody, it's just like when your plumber comes. Well, I'll tell you this story. I made a mistake the other day of calling a plumber for my house based on a mailer in my mailbox, right? $79 for a clear out the line. And I did not Google review or I did not Yelp review them beforehand. I was entrapped by that $79. And so I called the guy out and I immediately regretted it. It was on Labor Day weekend and I could tell it was going to be a song and dance when 5 minutes into the thing, he says, "Oh, come here, I got to show you something." So, you see this black sludge? You're in a lot of trouble. I'm like, oh no. And so he proceeded to start trying to sell me stuff. All I wanted was the line cleared out so that my garbage disposal and dishwasher and washing machine would work. And I said, just clear it out and I'll take the risks on whatever else you think is going to happen back there. But he's trying to sell me a bunch of stuff. He said, oh, I can do it, but I can only guarantee it for, well, I said, how long? I mean, if you clear it, how long do you guarantee it for? It's like 2 days. Until Monday, right, when I can call another contractor. So I had to leave and he did not clear it. I wrote him and told him, don't cash my check. I had to call Roto-Rooter and Roto-Rooter came and they would only guarantee the clear out for 30 days, right? And so what that would have meant is if 28 days later after Roto-Rooter cleared out my line, if my garbage disposal backed up again, they would have come back out and cleaned it for free. All right. And it's the same thing for warranty provisions on your big painting job or on your construction job or on your asphalt redo. How long is that going to last? And so I better check my check register to make sure he didn't cash that check. I don't think he did. I took pictures of the text and I showed him how it was backed up 6 hours after he said it was cleaned and it was guaranteed for 2 days. So they ensure how long you get to make a claim against them for the work or the service or the product. And sometimes there'll be a hybrid. If in the painting contracts, the painter will guarantee their labor to install the paint, and the paint will also have a product warranty on the paint. So and they will sometimes refer to it. Or if you're installing a water heater, the person who installs it will guarantee their labor, and the water heater contractor will guarantee the installation of or guarantee the product itself. And those will be subject to certain requirements, usually, like if you're getting a water heater installed in San Jose, make sure that you understand the hard water requirements associated with those water heaters, because they can fail quickly and they may not be covered under the warranty if there's hard water and things like that. One of my clients learned that the hard way. So, and it was a $50,000 endeavor. And so if the warranty language isn't clear and precise, you might not get it fixed when it should be fixed. Now, California has laws on the books about the implied warranty of fitness for a particular purpose for a product. And what that means is a product that says it is to do something should do it, at least for a year. And if it doesn't, the person who sold that product has to make up for it. So there are a couple of laws too that you can buttress your contractual agreement with, or at least be aware of in the background if there is no warranty language in your contract. Termination. Okay. A lot of them don't have any clauses. And usually you'll want to have them in so that you can end the contract if it's not going the way you want it to, if they're breaching the contract, or if you're accused of breach, or if you aren't getting along with the vendor, they're doing work, but their attitude is crappy, and you would want to have a basis to get out of the contract for no reason or any reason whatsoever, or if there is a breach. And so there should be provisions in that, in the contracts, the big ones at least, that set forth those kind of those circumstances under which you can terminate. So that's what I was talking about there. Termination for cause or termination for convenience. Cause is when, you know, they said they were supposed to have 5 workers out there a day, and they agreed that they would get it done in a timely fashion. They don't have 5 workers out there every day. They have 1 or 2, and it's taking a lot longer than it is. And then there should be provisions in the contract that govern that situation, and they're usually in the termination provisions. And usually you will want an opportunity to have that vendor correct it, because it's much more expensive to start up again than it is to have this contractor just fix what is wrong. So, and so too for you, if you can't make your payment on time because you missed a board meeting or the board was sick or whatever, and you would want to have an opportunity before the contract is just nixed to cure or fix that breach. And a lot of contracts will have that. And they'll say, you know, give notice, and then if 10 days after the notice you don't fix it, then we can breach. Obviously, you should consult legal counsel before terminating. You want to make sure that you're doing it correctly, that you have a good basis to do it, and you want to understand what is going to happen when you do it. Like who owes what kind of contract, or do they have to give you the contract documents back? Who owns the intellectual property for the plans and all of that? So if you're going to terminate, if you're having difficulties with a particular contractor, that's another thing that we can help with. Oh, wow. And that's it. All right. Let me back out of there, and I'd open the floor for any questions that anybody's got. Where is everybody? Did I just hang up?
Nope.
No.
I got you.
There you are. Okay.
Colin, I
We're
thought of
here.
a question. Or go ahead, Diana.
Go ahead, Brent.
Oh, Colin, I thought of a question. I think I see it sometimes, but maybe not all the time on contracts, that where the HOA signs it and the managers turn it in, but it's also for the company itself should sign it and then return it back to the HOA, so that shows that both parties have agreed to those terms, right?
Yes. Yeah. You'll definitely want a fully executed contract is what you're talking about. So it's contract is not enforced until both parties sign it usually. And there are general provisions in most contracts will say that you're allowed to execute it in counterpart. And what that means is that it used to be you'd have to both sit down at the table at the same time and sign it, right? But now they say the nature of the modern world, you can shoot off the contract. One person can sign it at their desk, and then the other person can sign it at their desk. They won't have the signature of the other, but you merge them together. And then it will be a fully endorsed contract. And yes, you will definitely want to keep that in your file, because the attorney will need that when the breach goes down and when you need advice on it. That's the first question we'll ask is, where's the fully executed contract? So yeah, great question, Brent.
All right, guys, any other questions you have for him?
Hmm.
The dog owners know my dog joke, right?
I don't.
Yeah, you probably do. It's did you hear about Ivy knows it. I wonder if Ivy knows the punchline. I've told it so many times. How much you hear about the zoo with just one dog in it?
No.
Ivy?
It's a Shih Tzu.
Oh, there you go. Maybe I have heard of that.
I'm glad you remembered, Ivy. You're getting there.
I only get it on new Queen.
I didn't mean to pick up. I'm on a Zoom call. Sorry, that was my kid. Sorry. And she literally calls me to just show me her dog. She's 26. There's nothing wrong with her. She just,
Oh, that's nice.
yeah.
There's
Look at my
nothing wrong
dog. No, like, you know, when people call me during the day, like, what's going on? She's fine. She just wants to show me her dog.
Really miss you.
You're right. Anybody else have any questions for Colin?
All right. Well, thanks so much for allowing me to help. I really appreciate it. I enjoy it.
Thanks, Colin. And I always reach out to Paul, but if you guys have suggestions on the next topic to cover, because you guys know what you're dealing with, rather than us, you know, feeding you something you may not want to have, just email me if you have suggestions. I would appreciate that.
Okay. Yeah, maybe I know Brad's on here too. We always look for those email blasts, and Brad sent out one today about the new election law thing that the governor signed.
The reduced quorum requirement dropped to 20%.
Yeah.
Yeah.
That's a good one to cover.
So it might be any recent laws that might have been
Yep.
passed.
We could do recent laws. Yep. I will bring that to Paul and Julie's attention.
Yeah, I think that'd be really good.
Recent laws, specifically the election.
But Brent, am I not doing a good enough job? No, I'm just kidding.
That's great. But I think the next step is I wonder if we have to update our election rules, possibly with that.
And I think that would be the premise of the discussion is, what do we as managers need to do to update, or even if we need to update, or does this new law supersede what's out there, blah, 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 blah.
Exactly.
I know that we'll talk about, we have an internal meeting every Friday, and the partners will talk about things like this. And I think you guys already have a plan going on, right, Colin, to figure out how we bring information to you on how to get your clients in compliance.
Yeah.
So we'll figure it out. We'll get you that information. I think we have a hard deadline internally, so it's coming. It's coming.
Great. Well, thank you guys. Appreciate it.
Thank you. Email me if you guys need anything else. We're here for you.
Sounds
Thanks,
good.
guys.
Thanks,
Thank
guys.
you.
Bye,
Take
guys.
care.
Thanks.
Have a
Bye.
great day.
Bye.
Bye. Thank you again.
And how do I? Oh, there it is. Okay. Bye, guys.